What happened next was depressingly predictable. They didn't watch the videos. Instead, they came back to my staff with a new instruction. A little notice provision of North Carolina law gives the state sweeping power to confiscate a person's entire estate when they die. Under North Carolina General Statutes 116B 2.2, the government is authorized to step in after death, take control of homes, bank accounts, investments, and personal property, and absorb that wealth right into the state coffers. This statute lays out a clear legal pathway for the state government to claim ownership of a deceased person's assets, effectively overriding family expectations and private intent. For anyone who assumes their property automatically stays within the family, this law paints a far more troubling picture of what can happen once the state gets involved. And if that sounds outrageous, it should, because if all you heard was that headline and that first paragraph, you'd be furious. Now, here's the problem: none of it is actually true, but you'd never know that if you stopped listening right after that first paragraph. And that's exactly the point of today's video. I'm Jeffrey G. Marsace, the plain English attorney, and we're going to explore how just looking at headlines and simple solutions doesn't always work. North Carolina General Statutes 116B 2.2 does not allow North Carolina to swoop in and take estates away from families. What it actually says, once you read the rest of the law in the statute it ties into, is that the state only receives property if someone dies without a will and without any legally recognized heirs at all under North Carolina intestate succession law. No spouse, no children, no parents, no sibling, no nieces or nephews, no distant relatives, even several degrees out of cousins. Only when there is literally no one left to inherit, all the way down to fourth cousins, does the estate go over to the state government. And here's another inconvenient detail that never makes the headline. This statute has been on the books for decades. It's not new. It's not a policy shift. It's not a land grab. It's a backstop for very rare edge cases. The first version works because it triggers an emotional reaction and because it's accurate. And if you react instead of reading, you'll walk away angry, confident, and completely wrong, but you won't get the full picture. Probate is often downplayed by the very attorneys who make their living doing it. If an attorney told you, you don't need a trust, probate's no big deal, drop a comment and tell us what happened. And like and subscribe for more information in plain English. Which brings me to a very real story from my own practice. Recently, a widow and her adult daughter contacted my office with what they believed was a very simple request. They wanted us to just type up or create letters testamentary so they could take control of a bank account in the husband/father's after he passed away. In their minds, probate was a formality, just a piece of paper standing between them and the money that was already theirs. So I did what I always do in situations like this. I sent them a 3-part video series I created explaining here's how probate actually works in North Carolina and why courts, not attorneys, issue letters testamentary. Why those letters don't exist until a judge signs off, and why probate can be far more involved than people expect, even though there are some limited exceptions that make things, in certain cases, easier. I also explained very directly that asking me to type up letters testamentary is like asking a lawyer to type up a court judgment awarding you millions of dollars. That document doesn't exist until and after a judge rules after a case, and sometimes that takes an awful lot of time. What happened next was depressingly predictable. They didn't watch the videos. Instead, they came back to my staff with a new instruction. Well, if letters testamentary weren't possible, then we should just go ahead and do letters of administration or an affidavit for collection instead, because that's what the bank told them to ask for. Same mindset, new buzzwords. They skimmed the situation, grabbed onto phrases that sounded easier, and assumed the outcome would change if they just used the magic words, without bothering to understand how the system actually works. The problem wasn't lack of information, it was a refusal to engage with it. They wanted it to be simple. And because they wanted it to be simple, they rejected anything that suggested it wasn't. And this doesn't just happen with estate planning, it happens everywhere. News media makes money off of attention, clicks, shares, fear, and outrage. Accuracy matters far less than engagement. So truth just takes a back seat to say what people want to hear and not the truth. During my recent social media detox, there was a video on that. If you want to go ahead and check it out, we'll make sure it's linked below. I noticed just how often people react to headlines that confirm what they already believe without reading a single word further. One of the first videos I watched afterwards, after that break, talked about a municipality in the Chicagoland area installing 2 EV charging stations at a town hall. The Facebook comments were brutal. People were furious about taxpayer money being wasted, furious that no one drove electric vehicles anyway. The town would have to maintain the chargers at the public expense. Total waste of taxpayer money, according to the comments. Every single one of those claims was false. The company installing the chargers paid for the equipment and installation. The town was seeing increased EV adoption in the areas, electric vehicles, and the municipality was receiving a percentage of the charging fees to help cover the maintenance costs. All of that was clearly explained in the post, but no one read it. They reacted to the headlines they wanted to be true. I see the same thing constantly in estate planning. Colleague recently told me about a prospective client who proudly announced she didn't need a revocable trust because she had a quote better plan. Her plan was beneficiary designations on all of her accounts to her children and grandchildren, and a will that imposed age restrictions on the grandchildren's inheritance. She was loud, she was confident, and she was completely wrong. Someone, maybe the bank, told her beneficiary designations avoid probate. That became her headline. And she stopped reading. She stopped understanding. What she didn't understand is that her will's age restrictions are meaningless for assets that avoid probate. The will only controls probate assets. Those accounts go outright immediately with no age protection at all. Unfortunately, she will probably never realize how wrong she is because she liked the headline she was given. Just like the family who wanted letters testamentary, just go ahead and put that together. They're going to keep calling law firms until they're told what they want to hear. Sometimes you actually have to do the reading, not just with estate planning, but with laws, news, finances, and decisions that affect your family. Headlines are designed to provoke reactions. Understanding requires effort. If you actually want to understand probate, and more importantly, how to avoid it the right way, there's free information available at freetrustcourse.com. But please, don't just stop at the headline. As I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.